Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Nabila Irudina BT Idrus, number metric 2318468. I am from Group 5 for Administration of Law Rkfq 1330. Our topic is conflict of jurisdiction between Sharia and civil court, case study of Nick Allen. The background of the case. In 2022, Nick Allen Zurina and Tengku Yasmin Natasha challenged 20 provisions of the Criminal Sharia Code 1, enactment 2019 by the Kelantan State Legislature for allegedly exceeding state powers under the Federal Constitution. The case attracted public and media attention due to its impact on the relationship between civil and Sharia courts in Malaysia. Federal Court Decision 9 February 2024, 16 provision invalid for exceeding state powers, Section 13 and 20 valid within state jurisdiction. The last one, petitioners withdrew, challenge to Section 5 and 37. Impact from this case clarifies the boundaries between federal and state legislative powers, emphasize the supremacy of the federal constitution while protecting Islam as the religion of the federation, Article 3. Demonstrate that the federal constitution guides the resolution of jurisdictional conflicts. Concept or definition from this case, dual judicial system in Malaysia. The first one, civil courts handle criminal, civil, commercial and administrative case. Sharia courts handle Islamic personal law, family, estate and certain moral and muamalat offence. Jurisdictional conflict from this case accused when state laws overlap federal jurisdiction. Federal court ensures states do not exceed powers while retaining the role of Sharia court in valid state case. The key principle from this case, supremacy of the federal constitution, Article 74, 77 and 81. Limits on state legislative powers, and the last one, Islamic protection maintained without violating federal power. That's all from me for introduction for this case. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aisha Hana binti Khairul Anwar and I will continue the presentation. Inshallah, we will go through about how does this case of Tengku Ni Ali Zurina versus Kelantan State Government was emerged. So this case was emerged when Tengku Ni Ali Zurina and her daughter Tengku Yasmin Natasha filed a challenge against the Kelantan Sharia Criminal Code Clause 1 2019. Their main argument here was that Kelantan State Legislative had exceeded its power by creating laws that overlap with matters that are already governed by federal criminal law. In other words, the impound provision were general criminal offences which fall under the exclusive jurisdiction of federal parliament and not the state. To clarify this, in Article 4 Clause 1 of the Federal Constitution states that any law that is inconsistent with the Constitution shall be void. To the extent of its inconsistency, Federal Court had to determine whether the provision that challenged by Tengku Ni Ali Zurina were genuinely religious offences based on Islamic precepts or whether they were general criminal offences which are fall under the federal jurisdiction. After analysing the provision, the court held that although these acts are prohibited in Islam, they were still considered as the general criminal offences. This means that creating law are fall on the federal parliament. So this case became a landmark judgment because it reaffirmed that the limit of state legislative power and the supremacy of the federal constitution in matters of criminal law. Now, let's move to the implementation of Islamic law based on this case. In fact, Kelantan enacted the Sharia Criminal Code Clause 1 Enactment 2019 to apply Islamic criminal law such as hudud, qisas and ta'zir, restrain Sharia principle and promote moral discipline, spirituality and community of well-being among the Muslims. So the implementation of Islamic law in Malaysia is subject to the federal constitution. Under the state list, state may legislate offences against the precepts of Islam. So the states are only allowed to legislate on matters that are pure religious in nature. Now let's move to the characteristics of Islamic law during this period. First, it is subject to the federal constitution. Islamic law in Malaysia is governed by the federal constitution, which are the highest law of the country. Although the constitution states that Islam is the religion of the federation, the court emphasized that Malaysia is a multi-ethnic and multi-religious society. However, state cannot legislate on ordinary criminal law because matters such as criminal offences and criminal procedure are reserved to the federal government. So here, the constitution wants to ensure the uniformity and consistency in legal matters across Malaysia. It also prevents any state Islamic law contradicting federal law and violating the constitutional rights, including those related to the religion, equality, and due process. Next, limited state power. Islamic law are mainly enacted by the state government, but their powers are limited by the federal constitution. Under the state list, non-scheduled list 2 stated that states can only make law on offences by Muslims against the precept of Islam. This legislative power is not absolute because it is bounded by the specific constitutional limits, which is first, the state powers applies only to matter under the state list and not the entirety of Islamic law. Second, matters included in the federal list or governed by federal law take precedence, limiting state enforcement in those areas. Third, Islamic offences legislation by states must align with the federal law and constitutional provision, such as Article 11 Clause 4, which controls the propagation of religion to Muslims. Fourth, the jurisdiction of Sharia court and state laws is confined to Muslims and not extend to non-Muslims. And lastly, there is a constitutional need for federal parliamentary to define what constitutes offences against the precept of Islam and to delegate jurisdiction to Sharia courts, after which states can enact related law.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Radiatul Syarifah binti Muhammad, and now I will continue the presentation with the topics sources of Islamic during this period. So in Islamic law, there are several types of sources. First one is primary sources, which is follow the Quran and the Sunnah. Next is the secondary sources, which is ijma, consensus of Sahaba and Qiyas, analogical reasoning. And secondary sources also includes istihsan, ijtihad, taqlid, and also fatwa. There are also schools of law, which is Hanbali, Hanafi, Maliki, and Shafi'i schools. So these schools of law have a slightly difference in their methods of interpreting Islamic law. For Malaysia, we use the Mazhab Shafi'i as the basis for the most interpretations in matters of Islamic jurisprudence. Furthermore, Islamic law in Malaysia is codified through state enactments under the Federal Constitution. So the Federal Constitution will define the scope of state powers and also limits the Sharia enactments within the state jurisdiction only, like family law and religious observance. So in the Nik Elim Zorina case, the Kantar Sharia Criminal Code enactment 2019 does not explicitly write the Quranic verses or hadith, but the entire framework is rooted in Islamic law sources. For example, the offences and classifications are derived from the principle of fiqh jinayah, which is Islamic criminal jurisprudence, that is based on the Quran and hadith itself. And then the enactment relies on the classical Shafi'i jurisprudence and contemporary fatwa authorities. Next, the categories of offences, like ta'zir offences, relating to protecting religion, life, intellect, property, and knowledge, are a reflection from the maqasid al-sharia, which is the objective of the sharia. And lastly, the inclusion of the 33 new sections in the 2019 enactment represents the use of ijtihad. Alright, now I will talk about the comparison between civil law and Islamic law. Malaysian law operates under a dual legal system. First one is civil law that derives from the federal constitution and statutory enactments, and then Islamic law that applies to all Muslims through state legislation. So now let's dive into the comparison between civil law and Islamic law. So the first one is from the authority aspects. For civil law, it derives its authority from the federal constitution as the supreme law of the land. So the criminal law falls under the jurisdiction of federal constitution, while Islamic law derives its authority under the state legislation by only the matters of Islamic practice and penal law only. So in this case, the attempt of Kelantan state legislation to legislate the criminal offences was struck down by the federal court because it had exceeded the state's constitutional authority. So the second aspect is from jurisdiction aspects. So for the civil law in Malaysia, it has a universal jurisdiction, which means that this law applies to every citizen, so for everyone, without looking at their religion and races. While Islamic law has a limited jurisdiction, which means it only applies to Muslims. So the third aspect is the sources of laws. For civil law, most laws come from written legislation, which means legal rules are created by lawmakers are often influenced by the legal scholars. So these laws are written clearly in detail, so they can apply to many situations or cases. While Islamic law, like we discussed before, it is written in the Quran and Sunnah that's supplemented by Ijma, Qiyas, and Mazhab Shafi'i. So there was no codification in the Islamic legal system. So in this case, Sharia enactments are based on Islamic laws, but the application is constrained by the federal constitution. Next is from the objective aspects. So for civil law, the objective is to ensure the public order, consistency, and equality for everyone. And it is also to provide the legal framework that applies to all citizens without looking at their religion. While Islamic law, the objective is to uphold the maqasid al-sharia, which protect the religion, life, money, intellect, and also property. It is also to uphold the social justice, including the property rights, economic decision making, and types of economic freedom. Alright, the last one is the oracles of law. For civil law, jurists are the one who develop legal theories, organize the law, and provide the intellectual structure of the legal systems. So the judges will just apply the law that have developed because the judicial discretion for them is limited. While Islamic law, the jurists, especially mujtahids, are highly honored because they interpret the Quran, the Sunnah, and also the other sources to elaborate and formulate the law. So the judges will just follow the accepted view of their schools. But if the judge himself is a mujtahid, he can interpret the law directly but within his school's framework. I think that is all from me. Thank you.
Bismillahirrahmanirrahim. Thank you to all my friends just now who provided great info a while ago. Next, I next one will present the next topic, which is important literature. First one is an article which is a tale of two systems, Sharia and civil law in Malaysia. It's offer in-depth explanation of Malaysian dual legal system, discussing the historical development of Sharia law, its underlying principles, and how it operates alongside civil legislation. The second one, the block called Legislation and Regulation of Islamic Law in Malaysia. It examines recent developments in federal and state law, highlighting changes in state criminal statutes and policies, and analyzing how these interact with broader federal legislation by offering a contemporary perspective. This source helps contextualize the challenges faced by lawmakers, courts, and individuals navigating overlapping jurisdictions. The third one, the online book that called What is Sharia Law? It expands on the general principles and concepts of Sharia law, providing comparison with Western legal system that allow readers to appreciate both the differences and similarities between legal frameworks. Furthermore, a study that also references, which is summarized of the Allen judgment. It provides a detailed overview of the federal court's decision, the legal reason that apply, and the specific provision and challenges. These summary are crucial for understanding the practical implications of the case, particularly regarding state legislative authority and constitutional limits. Then, let's move to another topic, which the example of application. The first one, the Iki Putra case. Iki Putra was charged in the Sharia court for attempting to commit libel under a Selangor state law. However, he challenged the law, arguing that the state did not have the power to create a criminal offence already covered by federal law. The federal law agreed with a ruling that the state provision was unconstitutional. Finally, the Indira Gandhi case in 2018, which involved a Hindu mother whose ex-husband, a Muslim convert. He also convert their children into Islam. While the civil court initially granted custody to Indira, the Sharia court has a conflicting order. The federal court ruled that unilateral compensation without both parents' consent is invalid, reinforcing that civil courts can review constitutional rights even when Sharia law is involved. This case highlights how jurisdiction conflicts directly affect family and parenting rights.
Assalamualaikum everyone. My name is Nurul Atikah binti Shahabuddin. Now I will be presenting the analysis of the Nick Edin case involving the Kelantan Syariah Criminal Code Enactment 14. The case began when a petition was filed in the exclusive original jurisdiction of Federal Court by Nik Elin Zurina Nik Abdul Rashid and her daughter, Tengku Yasmin Natasha, seeking a declaration that impugned section of Kelantan Syariah Criminal Code Clause 1 Enactment 14 were invalid and hence null and void on the ground that the legislature of the state of Kelantan and thereby the Kelantan state government as the respondent had no power to make those provisions. Before addressing the main issue, the respondent raised three preliminary objections. First, they argued that the petitioner had no local standing. Second, they claimed the petitioners had named the wrong party, saying the correct party should have been the Kelantan State Legislature. Third, they relied on what they described as expert opinion to interpret the constitution. From these objections, several legal issues arose. First, did the petitioners have local standing? Second, did they name the correct party? Third, could the respondent rely on expert opinion to interpret the constitution? And most importantly, did the Kelantan State Legislature even have the power to enact those provisions? Now, let's move to the Federal Court's decision. On local standing, the court held that Article 4 Clause 3 and 4 Clause 4 do not require a petitioner to prove personal reasons before challenging a law's constitutionality, so this objection failed. On the second objection, the correct party. It defies any logical interpretation of Article 4 Clause 3 and 4 Clause 4 to assert that the government of a state could not be named as a party to this petition. The government of the state is a proper party to be sued. So, this objection was also dismissed. The third objection on expert opinion. Only the courts are entitled to interpret the federal constitution. No other party may provide a legal opinion on how the provisions should be interpreted as a matter of law. Parties may present their competing view in the form of legal submissions for the court's consideration, but providing expert evidence on the interpretation of the constitution is not an accepted method of constitutional interpretation. Last but not least, on the constitutionality of the provisions, the court emphasized that criminal law falls under exclusive federal power. The state cannot legislate on criminal matters simply by framing them as Islamic precepts. Because the impunged section were essentially criminal in nature, they were ruled unconstitutional. Based on this previous case, the legal implications are significant. First, the case reinforces the supremacy of the federal constitution under Article 4 Clause 1. Any law inconsistent with the constitution is void. Second, while Islam holds a special position under Article 3 and 11, this does not override the constitutional division of powers between federal and state government. It is worthy to take note that the rationale behind the separation of legislative jurisdiction between the federal and state legislature is to avoid the issue of overlapping and redundancy of legislative jurisdiction between the parliament and the state legislative assemblies. Therefore, the judgment of the apex court in the case of Nick Edin should be taken in the right spirit by all the parties concerned, particularly the state legislatures, to do all the needful to ensure that the state law are in conformity with the federal constitution.
So Bismillahirrahmanirrahim. So we will continue to the discussion. So in this case, the issue of this case is arose because of the state and the federal parts had the overlap powers. Yeah, the Kelantan Sharia Criminal Code contained offences that already under the federal criminal law. So according to the Article 4 Clause 1 of the Constitution says that the federal constitution is the highest law. So even though the law is related to Islam, so that's the state government still cannot make the law when it is the constitution has assigned it to the federal power. Yeah. So the decision is the 16 Kelantan Sharia criminal provisions was struck down and two more were still under the state government and two more withdrawn. These decisions lead to the public react the different way. Some people says that this way to attack the Islam, and some people says this is the government authority to make this law. And also there are words secularity that we discussed before in the introductions. So some people thinks that the constitution are being neutral to religion. Yeah. And in actually the court decision is only to explain the different the separation between the religion matters and the lawmakers powers. It is about the powers, yeah, not the religion. So this separation is really important to make our legal system more structured and consistent. Yeah. So for the last one is this case also need some improvement, right? So for the first one is the public confusion after the judgment. We can see that our legal education system need more stronger through the school and also social media and what the public awareness program, because we can spread the understanding, this legal understanding, not just for the students and but we can spread it also to the all community level. Yes. Then is the public also need the clear explanation between the Sharia court and also the civil court about it. And also the last one is the important is the state and the federal lawmakers should coordinate or should work together to make our law is not contradict in the future. So this step is really important to help Malaysia maintain stable and have effective legal system. Yeah. So in conclusion, this case shows that the conflict between the Sharia and civil court is because of overlapping power, not because of any threat to Islam. So the federal court decision is justified and it was made purely based on the interpreting the constitution, which is the highest law in the country. So if Malaysia want Islamic criminal matter to be placed under the Sharia court, it must be done through the parliament, not a state, not alone. So this this is really important to have a clear understanding and coordination between a state and the federal lawmakers when making law. So we also see that the public need more stronger legal awareness so that the court decision will understood and not misinterpreted as a religious issue. So by improving the coordination between the institutions and stronger the legal education will help Malaysia build the more stable and prosperous legal system, inshallah. So with that, thank you for your attention. Assalamualaikum warahmatullahi wabarakatuh.